At this point in time, we're going to go ahead and bring up the next case. And this will be case number 241565, Alban Reed individually and as the administrator of the estate of Marietta Muchow, appellant, versus Lisa Muchow-King, appellee. The appellant this afternoon is represented by attorney Nathan Schroeder, and the appellee is represented by attorney Brian Foddrill. And counsel, whenever you are ready.
May it please the court, counsel. This appeal concerns the district court's erroneous finding that appellee Lisa Muchow-King rebutted the presumption of undue influence in relation to the transfer of real estate without consideration from her mother in February of 2019. The district court correctly found that Lisa was in a confidential relationship at the time the real estate was transferred to her. However, the district court misapplied the law in four specific and critical ways. First, it focused on Marietta's mental capacity in determining whether the act was voluntarily, intelligibly, and freely done. Second, the court found that Attorney Philip Stone's testimony and involvement qualified as independent advice. Third, the district court found that Lisa acted in good faith throughout the transaction, but the findings were based almost solely on Lisa's personal testimony and not supported by any other evidence. And fourth, the district court improperly shifted the burden back to Alban Reed, my client, with respect to the failure to call a witness who was the son of Marietta Muchow. Under Iowa law, when a confidential relationship exists between a grantor and grantee, as the court is aware, it causes that transfer to be presumptively fraudulent. And that shifts the burden to the grantee to prove by clear and convincing evidence that the act was free of undue influence. And the court has set out what those two elements are to rebut the presumption. The first is that the act was done freely, intelligibly by the grantor. And the second is that the grantee acted entirely in good faith.
Counsel, I've got a question about that standard. Have you found any cases where, one is met but not the other? I mean, so it seems to me that it's kind of like two sides of the same coin. One focused on, did the giver do it freely, intelligently, and voluntarily, and the other on was there any bad faith, or was it, all good faith on the other part? But is that, could there ever be bad faith that unduly influenced the transaction in a case where it also found it was free, voluntary, and intelligent?
I don't know if there's one where it's distinguished it. I know, at least I think it's in that Klein case in the state of Klein, the court makes note that the defendant or the grantee failed to prove good faith, but then the court went on to analyze the next element as well and also found that it was not freely, intelligibly, and independently done by the grantor. So I do think that there's a distinction. I would agree that there is some obvious overlap and it's hard to parse the facts between those two elements in that they're tied together. In this case, with respect to the freely, voluntarily, and intelligibly, the court focused strictly on mental capacity and essentially made a finding that mental capacity was sufficient to prove that element on behalf of Lisa. And we believe that that is erroneous under the law. There's clear case law that we've set forth in our brief where the courts, the Iowa Supreme Court and Court of Appeals cases where it has been stated that lack of mental capacity is not sufficient in of itself to prove that someone acted freely, voluntarily, and intelligibly. Notably because if they didn't have capacity, the deeds would be set aside for that reason alone.
I read the district court a little less critically. Don't you think the court needed to make those capacity findings before it could go on to fill the rest of the bucket with the analysis? You know, because if there isn't capacity, we don't go to the rest of the stuff, right?
Well, I guess I can see that distinction in that you wanted to get some of that evidence, and I do think that mental capacity does have some relevance to this element in and of itself, like it would in an undue influence case for susceptibility. However, the court stopped after making that determination and didn't look at any of the other facts related to whether Marietta was susceptible due to her dependence on Lisa. I mean, there's clear evidence that she was legally blind. She did not handle her own finances. She did not drive for 4 or 5 years before this. She couldn't make her own appointments. Lisa attended every appointment with her and had to drive her or had her daughter drive her. So I think when the court made that determination, it stopped short of looking at all the other facts that were involved.
What about, I mean, I know this is one of your other points that the attorney's testimony doesn't get you to independent, but isn't that another factor that that the court relied on as well? So how can you say it was just mental capacity when the court was relying on the meeting with the attorney as part of its analysis also?
I think, and this is probably where those two issues blend together with the good faith and freely and intelligibly. I think the independent advice is kind of looked at as a special type of element, whether it's there or not. I think the cases clearly state that when it's not there, you know, that issue alone can create a situation where it's going to be found to be fraudulent and not be able to overturn, or excuse me, to be able to prove by clear and convincing evidence. But in this situation, Attorney Stone's testimony was woefully short from what we've seen in other cases involving confidential relationship. I mean, if you compare the facts here to the Natvig case that we cited from the Court of Appeals, that involved a longtime attorney who had worked with the grantor on multiple occasions. The attorney testified that the transfer in that case of the farmland to the son was consistent with his discussions and statements over time, and it was consistent with his longtime estate plan. And we don't have that here. Attorney Stone had never performed any work for Marietta. It was a 30-minute or less meeting. She came with this express purpose of getting the warranty deed done and the powers of attorney. She wasn't seeking advice. She wasn't going to discuss this potential. She had already apparently made the decision when she made her 17-hour trip up there. So I think there's clear distinction that Mr. Stone in his testimony does not get to the level of independent advice. Do you have any
Authority that suggests that independent advice, as we use that term, requires everything there was in a case like Natvig? Because most people don't have a lawyer they see all the time, right? I think it's not uncommon for this kind of situation where I need some legal work done, I'm seeing a new person, maybe they know my family, maybe they don't. I'm troubled by the idea that we're only going to count the meeting with the lawyer if you've seen him before.
Well, and I think that's fair, and I do think there's cases that discuss it in more detail. I think the issue becomes is whether it's kind of a one-off meeting, and I don't think we're being too harsh on it. We're dealing with a situation where you're transferring. There's a transfer with someone standing in a confidential relationship, and the law already imposes a higher standard on those types of transactions to prove that it was freely, intelligibly, and done in good faith. So I don't think we're making a large distinction. We're not putting any additional work on an attorney that they shouldn't already be doing in terms of investigating or asking questions about the situation. But I think there's certainly cases where just going to the attorney to get a real estate deed done was a situation in the Herm estate, and the court found that just going for that express purpose, they've already made up their mind, they're not seeking advice, that's not sufficient for the independent advice for rebutting the presumption of fraud and undue influence.
Before your time runs out, what is your best evidence of lack of good faith with respect to the house transaction? I mean, you have quite a bit of good evidence that maybe in some other transactions there was, bad faith, but what is the best evidence you have that with respect to transferring the house, there was a lack of good faith?
With respect to that, the lack of good faith goes to the concealment, and that's a big point made in the Mendenhall case, that Lisa didn't disclose it to any of the siblings, no one knew about it, and she claimed that she didn't want to rub it in anybody's face. But when we look at what undue influence is, it's something that's practiced in the dark and not in public. And so if you have to rebut that presumption, you better make sure this is put out in public, so it can be scrutinized. And I see that my time is up. Thank you.
Time on rebuttal, counsel. Are you ready to proceed? All right, whenever you're ready.
May it please court, counsel. My name is Brian Foddrill. I am representing Appellee Lisa Muchow-King. We're asking today to have this court reaffirm the district court's, it was a careful, thorough, and well-reasoned decision that the district court in the second district made. And it involved a 3-day trial. It involved 5 witnesses plus the 2 parties. Nearly 40 exhibits were presented, including medical exhibits. Each party was allowed post-trial briefs, and it was a well-reasoned decision made by the district court judge. And counsel is correct. In our opinion, the district court correctly set forth the elements in the Mendenhall case. And the district court also very carefully analyzed each of those elements. And ultimately it decided that Lisa's actions were not the result of undue influence based on those elements and the exhibits and testimony provided. These kind of cases are hard because the one person that could tell us for sure is no longer here. And so there was a lot of objections made and kind of questions about, well, did this individual really say these things, or did she really do these things? And that's what makes these types of cases so hard, I think. And I'm happy to be here today, and the reason I'm happy to be here today is because I practice out of Clear Lake, and even in my practice, I run into this situation a lot where dealing with either the farmland up there or lake property where somebody wants to give their property to one specific child for whatever reason. And so I think this is an important case.
Jump off of that to talk about, I think perhaps her purposes, which were largely to keep it in the family. What good evidence do you have in this record that that was the primary motivating purpose for the transaction?
That's a great question. And I'm glad you brought that up because normally I would say I don't have any other than my client's word that that's what the decedent said. But in this case, the decedent's brother was the main witness on her behalf, Ron Van Way. And he even acknowledged that that is what the decedent wanted. She said she wanted to keep it in the family, and he also acknowledged that he got pushback from her because he continuously pushed for her to sell the property. And she said that she did not want to do that.
I guess for lack of a better word, got sick of hearing it from him too, right?
Now, this case is important for a lot of reasons, but you are asked to review this on a de novo review because this is court of equity here. And that's also important because under that type of review, the appellate courts give a lot of weight to the credibility and determination factors that were set out by the district court judge. That district court judge got to sit there for 3 days and listen to the parties and do what the judge does and judge them on their credibility and their truthfulness. And so that's an important factor to consider because, again, we have the whole situation where the decedent can't speak for herself. So we have to take each party's word for what the decedent said or didn't say. Now, as I said, the district court And I do want to point out that right on the first page of the court's order that came out in September of 2024, and I'm quoting directly from the order, it says, "The parties were extremely thorough in presenting their respective cases." So this was a well thought out and well discussed situation where the judge was asked to make a determination. And as I said, he properly found that the fiduciary relationship existed. Although, to be frank, we argued that it didn't even exist at first, because the facts of the situation were that when Marietta Muchow went back to Clear Lake from Broken Arrow, Oklahoma, a 17-hour round trip essentially, she went in and met with attorney Phil Stone. Now, when she did that, my client, Lisa, her daughter, brought her there, but was not present for the meeting. She didn't go into the Phil Stone's office. It's unclear for sure. I think she even might have said she couldn't remember if she waited in the waiting room or was out in the car. But in any event, she was not in that meeting with her mother. She also testified that she didn't know why her mother was asking her to come all the way back there. Now, whether you believe that or not, I think is actually irrelevant, because even if her mother said, "Look, I'm gonna have you drive me all the way back to Iowa, I'm gonna give you the house," that still in itself doesn't show undue influence. So lost track of where I was going with that, but
I think maybe makes this different than a lot of the cases we see. As I look at the record, there's almost no evidence of cognitive decline. Would you agree with that?
I agree with that totally. The only mention of that comes after the transfer of the property.
Make this different than a lot of the cases we see where maybe there's the suggestion, mom or grandma has started to develop, early symptoms. We can't pinpoint exactly where it is on the timeline of decline, but she is declining. Is that a distinction that informs what we do here?
I think it definitely should be. The other thing the district court said that I think is very important in its order is that, and again, I'm quoting here, the court finds that at the time the transfer in question, Lisa stood in a confidential relationship with Marietta, which we all agree on. However, it goes on to say that the court reached this conclusion not so much because Marietta placed trust in Lisa to handle her financial matters before her, but because Marietta was physically unable to do certain things. And I think that was the distinction the court made is, I'm gonna go ahead and for layman's terms, maybe throw the plaintiff a bone and say, you're right, she is in a confidential fiduciary relationship, but it's not because of the lack of mental capacity of the decedent. It's because she was physically unable to care for herself, which the record showed that was the case, and I don't think any party disputed that. So I do think it's a very big distinction here. There was, in addition to Mr. Stone testifying, who by the way was a very prominent attorney in Clear Lake, and still is. And at the time, he had been practicing 40 years. He testified that he's been involved in this type of situation many, many times, and he knows what to look for. Now, in addition to Mr. Stone testifying, now the district court doesn't talk about this specific testimony, but Marietta's banker at a Clear Lake Bank and Trust, Deb Duriger, also testified. She's a neighbor of Marietta, and would see Marietta all the time during the summers when Marietta would return, and testified that she had just saw Marietta at her daughter's wake, which was about 8 months prior to the transfer. And she testified that Marietta was the type of person that, in her opinion, there was nobody gonna pull the wool over her eyes. There was nobody gonna tell her what to do. Now, that's just her testimony, but that was left out of the record in the judge's order. But I think it was important to note that there was another neutral third party that said, Marietta is not the type of person that's gonna have somebody pull this over on her.
So let me have you pivot just for a moment with regard to the issue of good faith. Counsel had, in answer to, I believe, my colleague, Judge Buller's question, what's the best evidence of lack of good faith? The answer was the concealment or not disclosing the transfer. Can you respond to that?
Absolutely. And I'm glad you asked me that because I wanted to. To use the word concealment is unfair and doesn't really state what happened. Now, I will tell you that my client did testify in court that She was asked specifically, why didn't you say anything? The transfer took place in February of 2019. She says that she didn't know about it until her mother came back out and got in the car and said, hey, I gave you the house. She did say that right after that, she told her that. She says that's the first time she learned about it. The question then was why didn't you say anything to the rest of your family? This record is clear that this family is a bit dysfunctional, for lack of a better term. They were not close. And my client said, look, I didn't want to just go rub it in. What was I supposed to do? Call everybody up and say, hey, guess what mom did? On the other hand, I don't think it's her duty to do that. If anybody should have done that, it should have been Marietta. Marietta could have taken care of all of this, and we wouldn't be here today if she would have picked up the phone and called her brother or any of her other children and said, I'm giving Lisa the house. You know, here's my reasons why, and this is what I've done, and you guys need to just live with it. But she didn't do that. But to answer your question, you know, I don't think it was my client's obligation or duty to inform everybody.
Thank you.
Well, I say I only have 10 seconds left here, so again, we're just asking this court to reaffirm what the district court already found. Thank you.
All right, Mr. Schroeder, you do 5 minutes for rebuttal at this time, whenever you're ready to proceed.
I want to touch base on a few items that were raised. The first was in reference to the testimony of the banker. Deb, the neighbor, had testified she only saw Marietta 3 times between 2015 and 2018, and that would be outside the house when she was in the yard doing something. She never saw any interactions with the children during that time period. She testified that she had an interaction with her for about 10 or 15 minutes in summer of 2018. Importantly, Deb never talked about estate planning, never asked or never discussed what Marietta intended to do with her estate or her assets. And that's important because no one, not even the defendant, has come in here and said that Marietta always intended or always wanted Lisa to get the house. That apparently only magically appeared after her 3-month stint after having a stroke and ending up in skilled nursing. And after wanting to go into a long-term care and Lisa telling the long-term care facility she doesn't have the money. That's when this all came up, is when there was a potential of money being used for mom's care, and then all of a sudden she goes up and transfers the house. Now, what I think is another important issue and important fact that's not discussed is in these cases, when a person's standing in a confidential relationship, they have to do what's in the best interest of the person they're there to protect. And I think it's important if you take Lisa out and you put somebody else in to this situation, what would they have done in this situation? Would they have advised differently? Now, Marietta had spent 3 months. She had a CVA between December of 2018 till almost February, 2 weeks before this transfer took place. And then she ended up in the hospital again in June. Someone that's acting in her best interest, when they know she only has $150,000 in an IRA and some other checking account, is going to advise against transferring your main asset to somebody else.
Is there any evidence that Lisa gave advice about the transaction at all?
According to her testimony, she didn't give any advice at all. No pushback, no questioning, or anything like that.
To rebut that testimony as the evidence of whether there was advice?
No, there's been no evidence of any advice given for that type of situation. And, you know, I know opposing counsel had noted that, you know, Marietta didn't tell anybody after the fact, and it was her duty to tell, or if she wanted to tell, she could have. The testimony from trial was that she had discussions with Ron and with Carolyn afterwards, and stated that Lisa thinks she's getting the house and she's not. And those were after the fact. So there certainly was testimony to that effect. Now, obviously, the court didn't put it in the district court's ruling. However, to say that there's no evidence is not factual at all. The other point I want to touch on is the fact that the district court doesn't even get into any type of analysis of the fact this transfer is inconsistent with Marietta's estate plan. And the record is clear that she did a will in 2008, and then she did a codicil in 2015, which is less than 4 years before this transfer took place. And if this was her intention to keep it in the family, to not, or to want to give it to Lisa, that was her opportunity. However, she doesn't even discuss updating her will with the attorney, and he didn't ask her about it. That's nowhere in the court's discussion, and that is pivotal, because that shows what her plan was for at least the 20 years before that.
Does the will mention the house? I was under the understanding that the will just sort of had a remainder property piece. So typically, like when it's pivotal, as a factor, the will says one thing and then, the conveyance does something else. And I just wanted to figure out which bucket this one is in.
I don't think there is anything other than just, I'm giving it equally to my children. So I don't think it needs to call it out. This is clearly inconsistent with that provision of the will. And I see that I'm out of time. So I would just like to end and say that we pray that the court would reverse the district court's decision. Thank you.
And thank you both for your briefing as well as your arguments here this afternoon. We will consider this matter submitted, and we will get a ruling out as soon as we are able.